Hello, and thank you for joining Borden Ladner Gervais for our webinar series. My name is Eloise Graton, and I'm the co-chair of BLG's Privacy and Data Protection Group. We are pleased that you could join us today for one of our sessions. As many of you know, LexisNexis Canada recently published a book written by members of our team entitled Managing Privacy in a Connected World. And because of the tremendous interest in it, we developed this webinar series to provide you with an overview of a number of the chapters that we covered. 2020, as we all know, has been a very challenging year for many of us. But despite the new challenges with which we're often faced, one constant is that data protection and privacy issues remain leading concerns for organizations around the world. Privacy breaches, cyber incidents, smart technology challenges, privacy intrusive practices, and the opportunities and risk associated with artificial intelligence are just a few of the topics on which BLG continues to advise. I appreciate you joining us, and I hope you find today's presentation both informative and thought-provoking.
Hi, everyone. My name is Catherine McNeil, and I'm an associate in Vancouver's Corporate Commercial Group, and I practice in the area of corporate commercial law with a particular focus on privacy, cybersecurity, and related information technology matters. My chapter in Managing Privacy in a Connected World deals with personal information and outsourcing, which is what I'll be covering today. So my presentation today will follow an outline of three matters. The first, I'll provide a brief summary of relevant Canadian privacy law principles. The second, I'll provide organizational privacy law obligations for outsourcing. And finally, third, I'll provide practical recommendations for outsourcing arrangements. So on the first, the relevant privacy law principles, we'll start by talking about the legislation in Canada. At the federal level, we have the Personal Information Protection and Electronic Documents Act, which is known as PIPEDA. And then at the provincial level, we have personal information protection laws in 3 provinces that have been deemed to be substantially similar to the federal legislation. And those 3 provinces are British Columbia, Alberta, and Quebec. In each case, in BC, it's called the Personal Information Protection Act, or PIPA. In Alberta, the same thing, Personal Information Protection Act, which we call the Alberta PIPA. And then in Quebec, the Act respecting the protection of personal information in the private sector. Of note, the privacy commissioners in Canada have declared all of the provincial legislation to be substantially similar to federal legislation, which means that generally, and subject to certain limited exclusions, if you're in compliance with a provincial legislation, it generally means that you're also in compliance with the federal legislation. And so the application of federal versus provincial can sometimes be a little bit complicated. So we'll start with the federal legislation first. PIPEDA, the federal legislation, regulates 3 things. It regulates the collection, use, and disclosure of personal information in the course of commercial activities by private sector organizations in all provinces that do not have their own provincial privacy legislation. So as we just talked about, that would mean PIPEDA regulates in all provinces and territories except for BC, Alberta, and Quebec. Just a few technical notes. PIPEDA generally excludes not-for-profit and charitable organizations, as well as political parties and associations, unless, of course, they're engaging in commercial activities. And again, it does not apply to organizations that operate entirely within Alberta, BC, or Quebec. And the second thing that PIPEDA regulates is the collection and use and disclosure of personal information by federal works, undertakings, or businesses. And that's a concept that includes things like banks, airlines, railways, and telecommunications companies. And third, PIPEDA also regulates the collection, use, or disclosure of personal information across provincial borders. So it could be that you are a business or an organization located entirely within BC, your head office and your operations are in BC, but maybe you transfer personal information to another province in Canada, or you collect personal information from another province in Canada. And to the extent that that personal information is traveling across borders, either provincial or international, then even though the BC PIPA would regulate your activities within BC, to the extent there's a transfer across borders, then PIPEDA kicks in and PIPEDA applies to that transfer. So the important thing to note is that even though your obligations under PIPEDA and provincial legislation are generally fairly similar, two pieces of privacy legislation in BC or more could potentially apply to the same transaction or to your business. And another important privacy law principle is what is personal information. The thing to know here is that personal information is really broad, and it's defined under privacy law legislation about information about an identifiable individual, including information that can be used with other information to identify an individual. So you have things that people generally think of when they think of personal information, like name, email address, contact information. But then you can also have other things too that maybe aren't immediately obvious, like race or ethnicity, religion, age, marital status, medical history, employment history, educational history, financial information, DNA, identifying numbers like social insurance number, and even in some cases, the privacy commissioners have said views or opinions about employees is their personal information. And another thing to note about personal information is that it's not just limited to customers of a business, includes information about any individual. So that could be things like employee personal information or potential customer personal information. And if your customer is an organization, then it would be the personal information of their respective employees or investors or other people with whom you deal. There is one carve out for personal information under privacy law legislation in Canada, and that relates to business contact information. And as a public policy reason, business contact information, PIPEDA and the provincial legislation do not apply to business contact information, which means information that an organization collects, uses, or discloses solely for the purpose of communicating or facilitating communication with a person in relation to their employment, business, or profession. So this would be a work email address. And again, there is a carve out in PIPEDA, and then you also see the same kind of thing in provincial legislation. So we've talked about the privacy law legal framework in Canada, and an important thing to note for right now is that we are expecting some significant changes coming down the pipe, both federally and provincially. And the reason we're expecting these, the Canadian federal government issued in May 2019 the Digital Charter, which contemplates potentially significant changes to privacy law in Canada and advocates for potentially significant reform of privacy laws. And then also at the provincial level, we've had the Quebec provincial government has passed Bill 64, which is an act to modernize legislative provisions as regards the protection of personal information, which contemplates significant changes to Quebec's privacy law sector and public sector privacy laws. In BC, we've had a similar kind of thing. The BC provincial government recently concluded a consultation on the reform of the BC PIPA in August 2020, and we're expecting to see a report from that consultation early 2021. And then in Ontario, which you might recall does not have specific personal information legislation right now, the Ontario provincial government has initiated a consultation to strengthen provincial privacy legislation. So privacy law, some general principles. One thing to know is that Canadian privacy laws are based on what we call a model code for the protection of personal information. And this model code sets out 10 basic principles that govern privacy laws and all of the obligations contained in privacy laws. And those 10 are accountability. You have to be responsible for personal information. We'll get back to that one. Identifying purposes, you have to tell people what you're doing. Consent, you have to get consent. And again, we'll get back to that one too. Limiting collection, don't collect too much. Limiting use, disclosure, and retention. Don't over disclose, don't use it for other purposes, and don't hang on to it in perpetuity if you don't have to. Accuracy, you have to make sure it's accurate. Safeguards, got to protect it. Openness, you have to be transparent about what you're doing with personal information. individual access. You have to give people the right to access their personal information and correct it if they want. And challenging compliance, individuals can challenge you as an organization, your compliance with privacy laws in Canada. So for the purposes of this presentation today on outsourcing, we're going to drill down on 2 of those 10 general principles, the first being consent and the second being accountability. So on the consent principle, Canadian privacy laws require that you must obtain the knowledge and consent from an individual to whom the personal information relates, unless it's inappropriate. And there are some public policy carve-outs in the legislation for specific circumstances where you don't need to get someone's consent to collect, use, or disclose their personal information. But generally, if one of those exclusions doesn't apply, you need to get their consent. And further, consent has to be meaningful, which means consent is valid only if it is reasonable to expect that the individual understands the nature, purpose, and consequences of the collection, use, or disclosure. And the form of consent, one thing to note here, the form of consent can be expressed or implied, and what that form has to be depends on the circumstances, the type and sensitivity of the information, and the reasonable expectations of the individual. So if you're doing something really egregious or really unexpected with personal information, privacy commissioners generally expect that you're going to have to go get express consent from the individual or bring it to the individual's attention at specific time periods, just-in-time notices. But if it's something that's probably expected from the kind of transaction that the person is engaging with with you, then maybe express or maybe implied consent is acceptable. And organizations, the burden of proof is on organizations to demonstrate that they obtain consent, so organizations should retain proof of that consent where possible. The last principle, or the last thing to know about the consent principle, is that consent can be withdrawn at any time, subject to legal or contractual restrictions, but you need to tell the person the implications of withdrawal. If withdrawing their consent means that you can't provide your service to them, you need to explain that to them. And the second principle in the model code that we'll talk about today is the accountability principle. The accountability principle, at its most basic, imposes responsibility on an organization for personal information under that organization's control. And the accountability principle requires an enterprise-wide, multifaceted approach. It's not just C-suite, it's not just the IT team. Everybody needs to be on board to be accountable for personal information. And so that the privacy commissioners have held means that the organization on the whole has to know its privacy obligations. Not knowing your obligations under privacy law is not good enough. The organization has to develop and maintain a privacy management program, including appropriate oversight and training. The organization has to implement policies and procedures, including privacy policies, risk assessments, employee training, breach and incident managed response, service provider management, and ongoing review of all of those policies and procedures. And privacy commissioners have also held that if an industry standard or practical necessity is not a defense for failure to meet privacy obligations. So if everybody else is doing it in your industry, but it's still deficient of privacy law obligations, not sufficient. And again, practical necessity, if you only have finite resources or you didn't meet your privacy law obligations because of some sort of deemed practical necessity, again, privacy commissioners have not been particularly sympathetic to that and said that's not sufficient. So those are the relevant Canadian privacy law principles, and now we'll get into part 2 of the presentation, which is what are your obligations when you outsource for organizations? And to back up a little bit, outsourcing, most of you probably have a very good idea of what outsourcing means because you do it all the time. But just by way of background, outsourcing explained means an arrangement by which an organization engages a third-party service provider to perform a business activity, function, or process. Most of you are probably very familiar with many of these, but examples include IT system management, document processing, application processing, policy administration, marketing and research, back-end office management, HR services, and cloud services or cloud computing. And one thing to note about outsourcing is that it often includes the transfer of personal information across provincial or international borders to service providers located in other jurisdictions. It's quite often the case that your preferred service provider is not conveniently located in the province or territory in which you have operations, and you're using service providers that are either located in other jurisdictions or that have servers in other jurisdictions. In privacy law lingo, that's what we call cross-border transfers for processing. So outsourcing under PIPEDA, first we'll talk about outsourcing at the federal level, and then we'll get into the provincial level. But at the federal level under PIPEDA, outsourcing is not prohibited. However, you recall the accountability principle. The accountability principle is actually codified in PIPEDA, set out in Schedule 1 to PIPEDA. And the first part of the accountability principle that's reproduced in PIPEDA is Principle 4.1. And that says an organization is responsible for personal information under its control and shall designate an individual or individuals who are accountable for the organization's compliance with the accountability principle. So you're responsible, and generally you need a privacy officer or somebody similar. And then Principle 4.1.3 of the Model Code, which again is codified in PIPEDA, goes a little bit further with respect to third parties. And it says, an organization is responsible for personal information in its possession or custody, including information that has been transferred to a third party for processing. The organization shall use contractual or other means to provide a comparable level of protection while that information is being processed by a third party. So pretty express in PIPEDA. These are your obligations if you're going to use a third party to help you out. And then the Office of the Privacy Commissioner of Canada, who governs and enforces PIPEDA, has enumerated a number of principles relating to the accountability principle. And the OPC, the Office of the Privacy Commissioner of Canada, has held that the obligations under Clause 4.1.3 are satisfied by implementing a contract that contains a number of provisions, including first, confidentiality and security provisions about the personal information. Second, sets out minimum information security safeguards that the service provider must comply with. Third, sets out specific rules, regulations, and standards to which the service provider must comply. Fourth, enumerates roles and responsibilities of key stakeholders that handle personal information. Fifth, sets out acceptable uses of personal information. Service provider, here's what you can do with it, and here's what you cannot do with it. Six, sets out retention and destruction obligations at the end of the lifetime of the contract. Service provider, you have to give us back the personal information or demonstrate you destroyed it. You cannot hang on to it in perpetuity. And lastly, the contract has to enable you as the organization to be able to oversee, monitor, and audit what your service provider is doing with that personal information. And a little bit more guidance from the OPC, the Office of the Privacy Commissioner of Canada. The OPC has held that Clause 4.1.3 is not satisfied. Even if you have a contract in place, if you're unable to confirm what happens to personal information while in the custody of a service provider. Again, even if you have a contract in place, if you don't know what that service provider is doing with your personal information or the personal information that you've collected and then transferred to that service provider, you have not met your obligations under Clause 4.1.3. And just a little nuance, the OPC has noted that a contract might not be required in limited situations, but those situations are very specific, and it may be a little risky to rely on not having a contract. So things like where the OPC has suggested that maybe a contract is not necessary would be a situation where you're transferring personal information to a close affiliate as your service provider. the transfer is very, very limited and the personal information being transferred is not sensitive. Again, very narrow situation, and the best course of action is put a contract in place with your third-party service provider. So outsourcing under the Alberta PIPA. The Alberta PIPA, again, has a very similar provision codified that relates to the accountability principle and states in section 5.1 that an organization is responsible for personal information that is in its custody or under its control. And then the Alberta PIPA, contrary to other legislation in Canada, goes on to specifically reference third-party service providers in section 5.2 and says, for the purposes of the Alberta PIPA, where an organization engages the services of a person, whether as agent, by contract, or otherwise, the organization is, with respect to those services, responsible for that person's compliance with this act. The Alberta PIPA also has obligations specific to service providers located outside Canada, and we'll touch on that in a second. And then under the BC PIPA, there's no express reference to third-party service providers, but you see that accountability principle reproduced again. Section 4.2 states an organization is responsible for personal information under its control, including personal information that is not in the custody of the organization. And lastly, outsourcing under the Quebec Privacy Act. The Quebec Privacy Act uses slightly different language than what we see in the federal PIPETA and the BC and Alberta legislation, but it's a very similar concept. The Quebec Privacy Act requires a person who carries on an enterprise to take security measures necessary to ensure the protection of the personal information collected, used, communicated, kept, or destroyed, and that are reasonable given the sensitivity of the information, the purpose for which it is used, the quality and the quantity and the distribution of the information, and the medium on which it is stored. And the Quebec Privacy Act permits, in the carrying on of an enterprise, authorized employees, mandataries, or agents, or any party to a contract for work or services to have access to personal information without the consent of the person to whom the personal information relates, but only if the information is required for the performance of their duties or the carrying out of their mandates or contracts. And then, just like the Alberta PIPA, the Quebec Privacy Act sets out some obligations for service providers located outside Quebec, and we'll touch on that in a second. So that was outsourcing obligations generally under privacy legislation in Canada. And now we're going to talk about a discrete issue that has been a little bit in flux lately. And this is transferring personal information across borders to third-party service providers located in other jurisdictions. So we'll start by talking about the federal level, which has been the most dramatic out of all the legislation lately. And the starting point here is the OPC, which is the Office of the Privacy Commissioner of Canada, had established a policy position about transfers across borders for processing. And that old policy position was not codified in PIPETA, but rather it's set out in guidance. And the most important guidance is the OPC's document titled the 2009 Guidelines for Processing Personal Data Across Borders. And in that guidance document, the OPC says very clearly, a transfer of personal information to a third-party service provider for processing is a use of that personal information, not a disclosure. And therefore, additional consent is not required from the individuals to whom the personal information relates, provided that the service provider uses that personal information for a purpose consistent with the purpose for which the personal information was actually collected. So if you're using a service provider located in another jurisdiction to process financial payments and you're collecting personal information, financial information from your customers, they understand it's for processing payments, and then you just farm out that work to a service provider in another jurisdiction. OPC said, that's fine. You don't need to go ask the customer consent to go transfer that across the border. But as long as that service provider isn't doing anything else with it, that's okay. The OPC did, however, say transparency is required. And in most cases, this has been taken to mean that as long as you put a notice in your privacy policy that you might use third-party service providers in other jurisdictions, that's okay. And so that was the old policy position. And then there was a little bit of turmoil last year, which all started with PIPEDA report of findings, number 2019-001. And in that report of findings, the OPC had investigated the privacy practices of an organization. And in the course of analyzing the privacy practices of that organization, changed its policy position and held in this report of findings that a transfer of personal information for processing was now a disclosure, not a use. And further, that to be able to do that, you had to go back to the customers to whom the personal information related and get additional express consent for the disclosure. As you can imagine, this presents a lot of administrative difficulties for a lot of organizations. And in many cases, it's just not practical or feasible to go back to customers and ask, hey, can we transfer your personal information to our service provider who happens to be located in the US, for example. So the OPC had a bit of a tumultuous summer. They did a consultation over this. They reframed the consultation. They opened it up for an opportunity to comment. It was criticized fairly harshly. And then following that summer, the OPC concluded in September 2019 that there was no change to its policy position and the old policy position would prevail, no additional consent. Happily for many organizations, the OPC affirmed its old policy position and doubled down on the old policy position in a recent report of findings that was issued just earlier this year, confirming, yes, old policy position applies, and no, you don't need to go get an additional consent. So outsourcing across borders, that was the federal level, and then now at the provincial level, there are a couple little nuances, but generally the same sort of thing. The Alberta PIPA says you can use a service provider located outside Canada to collect, use, disclose, or store personal information on your behalf. But if you do, then you have to include information in your policies and practices about, one, the countries outside Canada in which the collection, use, disclosure, storage is occurring or may occur, and two, the purpose for which the service provider outside Canada has been authorized to collect, use, or disclose personal information. So the thing to note about the Alberta PIPA, it requires a little bit more specific disclosures than at the federal level. And then the Alberta PIPA goes on to say that you must make available written information about the policies and practices on request. Generally, this is taken to mean a privacy policy that has to be available to customers and other people for whom you might be collecting personal information. The BC PIPA, a little bit more simple, no provision specific to the transfer of personal information across borders. And then at the Quebec, over in Quebec, the Quebec Privacy Act has said you can do it, but before you transfer personal information outside Quebec or trust a person outside Quebec with holding, using, or communicating personal information, you have to take, quote unquote, all reasonable steps to ensure that, number one, the information will not be used for purposes not relevant to the object of the file or communicated to third parties without the consent of the individuals to whom the personal information relates. And two, in the case of nominative lists, that the individuals to whom the personal information relates have a valid opportunity to refuse to consent to the use of their personal information for commercial or philanthropic purposes, or if necessary, to request that their personal information be deleted from the list. So those would be things like email, phone lists. And the Quebec Privacy Act has also said that if you can't satisfy those obligations, then you can't communicate the personal information outside Quebec or entrust a person outside Quebec with the task of holding, using, or communicating personal information. So those are the obligations on an organization for transferring personal information across to third-party service providers, including in connection with processing that might occur across provincial or international borders. So what does this look like in practice? And that's the tricky part for organizations. So now we're going to talk about some practical recommendations for outsourcing arrangements. And the first thing, as a preliminary matter, you have to do your due diligence. So that involves, and that's a pretty thorough assessment, but it involves first doing a risk assessment. Consider, is it appropriate to use that proposed service provider for that requested service? Understand the purpose for the engagement. What are we getting the service provider to do? Is it appropriate to do that? Can we do that? Um, and as part of your risk assessment, assess what kind of personal information will be transferred. Is it just emails? Is it a whole bunch of financial data? Is it medical records? How significant is this personal information? How much personal information? And as part of your risk assessment, you should include or you should conclude with an analysis of the potential benefits versus the potential risks. And the result of the risk assessment, if you do it properly, should conclude that there are more benefits than there are risks. Obviously, if their risks are too extreme, then maybe that's not quite an appropriate third-party service provider arrangement. The next part of the due diligence, understand the service provider's privacy and security practices. So this includes things like reviewing the third-party service provider's privacy policy in terms of service and confirming that the service provider has implemented appropriate policies and procedures. You need to know what they're doing with your personal information, and quite often that's a matter of looking in their privacy policy. Do they have anything weird in there saying that they're going to use the personal information for marketing or ancillary purposes, or they're going to be transferring it to a whole bunch of jurisdictions that you're not familiar with? Do they have anything in the terms of service about ownership of personal information? Things like that. Anything weird, you should know what they're doing and what they intend to do with your personal information. And then do due diligence on the proposed service provider themselves. Do a Google, see what comes up. Consider the experience of the service provider. Have they been doing this for years, or is this a startup in beta testing? Do they have the ability to provide the service? Again, do they have the resources, or is this a very new venture and you are the test subject? Do they have business reputation? What's their financial strength? Are they at risk of going under and leaving you in a bit of a lurch for that service? Have they had any past issues or complaints or litigation? All of this, just see what you can find and see if it seems like a reputable service provider who is able to provide the service that you want them to provide. And then lastly, as a matter of due diligence, think about the jurisdictional issue that we talked about before. Where is the service provider located and where are their servers located? Is it a jurisdiction you're familiar with? Is it one that you're completely not familiar with, or may have laws that are personal information laws that do not quite offer the same level of protection as Canadian personal information protection laws? These are important things to consider when you're deciding whether to enter into a contractual relationship with that service provider. So you've done your due diligence, everything seems to be okay. The next step is the contract. And the contract should contain provisions, or the contract could contain a number of provisions about ownership and security that we'll get into. Recognizing, however, it may not be feasible to include all of these provisions in there, or may not be appropriate given the service provider arrangement and the extent to which they're processing information. So all of these, the extent to which you include these will depend on the particular facts of the relationship at hand. So in a perfect world, consider including provisions that address ownership of data. You want to make it under not ambiguous at all that you own all of the personal information as between you two. You and the service provider, you own the personal information that you're transferring over to them. Confidentiality, you need to make it clear that they're under obligations of confidentiality. Safeguards, set out safeguards that they have to follow to protect the personal information you transfer to them. Permitted and prohibited uses, explain very clearly what they can do with the information and what they can't do with the personal information. Subcontractors, should they be allowed to use subcontractors? Do they need to get your approval before you use a subcontractor? Organizational control, set out controls over who is managing the contractual relationship, who's controlling it, and who are you dealing with at the service provider level. Audit rights, give yourself a right to go in there and look at their systems, look at look at the records that they have that you transferred to them and audit to make sure that they're doing what they said they'd be doing. Reporting requirements, do they have to come back to you monthly, annually, sending out a report of what they're doing with your personal information? Data breach reporting, notification, and record keeping. What happens if they suffer a data breach? Recall the accountability principle. If they have a data breach, you could be responsible for the personal information that was under their custody and control. So do they need to tell you right away that they suffered a data breach? Do they need to keep records of it just in case the privacy commissioner comes asking you what happened? And then you have a record based on that third-party service provider. Retention, deletion, and destruction. Separate obligations, what happens at the end of the lifetime of the contract? Do they have to destroy it? Do they have to confirm that they've destroyed it, return it all back to you? And if the contract is really long and over a number of years, how long can they retain personal information within the contract? Maybe they don't need it for very long and you have an obligation there that they need to get rid of it on an ongoing, continual basis. And termination, not specifically related to personal information per se, but this is pretty important. If the contractual relationship just isn't working out, do you have an ability to get out of the relationship? Or are you locked in for a long period with somebody or with an organization that you're not happy with and poses concerns for your privacy law obligations? That's a really important thing to look at. And insurance. Do you have sufficient insurance? Does your service provider have sufficient insurance? Do you want them to look into getting business insurance, cybersecurity insurance? Those are important considerations, especially if the value of the services provided is quite significant. And then risk allocation as between you and the service provider. Things to think about: is there an indemnity? Is the service provider providing you with an indemnity if you get sued in the event that there is a data breach or something else happened? Is there any limitation of liability? Are there exclusions from that limitation of liability? Quite often we see in contracts there's a general liability cap of some dollar amount, and then there's the carve out for breach of confidentiality or data protection obligations. So that meaning that the liability cap does not apply if there was a breach of a confidentiality wrap. And like I said before, the contractual provisions that are appropriate for your contract will depend on the circumstances of the situation at hand, including who the service provider is, what they're doing, and personal information you're transferring to them, and for what purpose. And then some additional privacy recommendations. So some other things that you can keep in mind for outsourcing to help mitigate your risks. Review and update your organizational privacy policy to reflect the use of service providers. Limit service provider access to your personal information. So don't give them more personal information than you need to. If they're only processing payment data, only give them stuff they need to be able to process payment data. Implement data sharing procedures for providing personal information to service providers. This means set out some sort of policy and procedure internally that limits how much data you share with the person or with the organization. So you're not just giving them a data dump of everything you have. There's some sort of control in place to make sure that they only actually get what they need to have. And then fourth point, consider if additional consent is required. Again, we talked about that consent requirement. The current policy position in Canada is it's fine to transfer personal information for processing, provided it was the third-party service provider will use it in a purpose that is consistent for the purpose that you originally collected it. If that purpose changes and the service provider is using it for something else, consider whether you need to go back to the customer and get another consent. And then implement and regularly update an organizational incident management framework. What happens if you suffer a data breach? What happens if a service provider suffers a data breach? Do you have people in place in your organization who will deal with it right away? Do people know what to do? Do you have legal counsel in place? Quite often data breaches happen very quickly, and the first 48 hours are quite critical to managing the data breach. And are you able to effectively respond to a data breach, again, within you or within your organization, or if you transferred personal information to a third-party service provider, the ability to respond effectively will really help mitigate potential exposure to liability. And finally, just monitor Canadian privacy law developments. As we've seen, a common theme throughout this presentation is that we're expecting privacy laws to change in the future. We don't know exactly how. It might impact outsourcing arrangements, but just keep an ear to the ground and just be aware that your privacy obligations might change in the future, and those obligations might change soon. So just keep yourself apprised of privacy law developments. And make sure if you have any questions, just consult with your legal counsel and make sure that you are in compliance with all of your then in effect personal information obligations. Okay, and now we will open it up to questions. And I see that 2 have come in. And the first is, what does an organization need to put in its privacy policy if it uses a service provider? So that's a great question, and we touched upon that briefly in the presentation, but you need to be clear that you're using service providers, and if those service providers are located outside of your jurisdiction, so either in other provinces or territories in Canada or internationally, you need to make it clear that service providers might be located in those other jurisdictions with as much specificity as you're able to. And you need to also be clear, you need to let people know that the laws of those jurisdictions might be different from the laws of your jurisdiction. And so the personal information might be subject to laws different from the ones of your jurisdiction. And question number 2, what should an organization do if it would like to use a service provider that is unwilling to negotiate terms and conditions? Again, a great question. This happens quite a lot, especially for service providers that are very large, like Microsoft or Amazon Web Services. And if your relative size of your organization is a little bit smaller, sometimes you might be presented with non-negotiable terms and conditions. The service provider says, take it or leave it. You can use our service, but we're not going to enter into modifications just for you. You have to use our terms and conditions. And that's when the due diligence becomes really important. You might not have a lot of latitude to negotiate the contract, but you can do a lot to protect yourself before you even sign the contract. So in those cases, I would spend particular emphasis on due diligence. I would think about, look at the reputation of the service provider. Are they really well known? Are they really frequently used? Do they have a lot of financial security? Has there been any rumblings in the news about any nefarious purposes they might be up to? Do you feel comfortable that they can provide the services provide the services you want and also in the ways that you expect them to? All of those things are going to be really important. And make sure that the other thing that I would do is make sure that you are able to get out of that arrangement if it's not working out for you. So I would take a look at the terms and conditions and see what is the termination provision in there. Can you get out on 30 days notice if you're not very happy with them? No questions asked, or are you locked in for a huge term under onerous provisions, onerous terms and conditions that you're not too happy with? That's something else. If it may not be that big of a deal if you can terminate the agreement right away, but things to keep in mind. Okay, and that concludes my presentation for today and wraps up our first session. Thank you again for joining me. I hope that you found the presentation to be both interesting and informative. And of course, if you have any additional questions or comments, you can contact me at the business contact information set out in this slide of the presentation.
That was a great presentation. Thank you for your wonderful insights. And thanks to all of you for joining us today. If you haven't already received an invitation to our next few presentations, you will be receiving one very soon. Of course, to find out more information about our team, our practice, and this webinar series, please visit our website at blg.com.